My name is LaTeal Pierre, and today I'm presenting an honest, no-nonsense evaluation of Priceline's terms and conditions, specifically Part 1, Sections A through F. If Priceline is serious about reviewing or updating its user agreement, then I'm here to give you the kind of clarity that makes a company strong. I'm approaching these terms the same way I'd approach any contract, directly, confidently, and with the expectation that we want it to hold up under pressure. Let's start with something many companies don't like to say out loud. The second a person lands on Priceline's website, they're treated as if they've agreed to an entire contract, whether they read a word of it or not. There's no pop-up, no acknowledgement, no moment of consent. It's passive and it's automatic. My role here is to take a clear look at whether that approach is strong enough to stand in court, and whether it builds trust with users, and whether it protects Priceline as much as Priceline thinks it does. To do that, I analyzed Priceline's terms line by line, along with best practices from Digital Media Law Project, commentary from legal experts like Eric Goldman, and the Electronic Frontier Foundation's Terms of Service Tracker. I also compare Priceline's structure to recent and historic law to see where the contract is strong and where it's vulnerable, and how it can be improved. My goal here isn't to criticize, but to strengthen, to make sure this agreement works exactly the way Priceline needs it to. From a legal standpoint, a real contract has an offer, acceptance, consideration, and mutual agreement. Priceline has the offer and consideration covered without issue. The question is acceptance, whether users truly agree to these terms simply by using the site. Courts, like in the case of Specht v. Netscape, have been very clear about this. A person cannot be held to terms they didn't see or didn't knowingly accept. So while Priceline's terms are structured as a contract, their enforceability depends heavily on whether the user actually had a fair chance to understand what they were actually agreeing to. Right now, Priceline uses what's called browse wrap, meaning the terms are simply linked at the bottom of the page and not actively accepted. Courts are becoming less patient with this practice. In Nguyen v. Barnes & Noble, a hyperlink at the page bottom wasn't enough to prove that the user actually agreed. And that's where Priceline runs the risk. The terms exist, they're linked, they're technically accessible, but accessibility and agreement are not the same thing. If this contract ever faces a challenge, that distinction will matter. There's another case that's even more telling, Long versus Provide Commerce. In that decision, the court said the terms were unenforceable because a reasonably attentive user still wouldn't have noticed the link at the bottom of the page. And that's the problem with browse wrap. Being technically available isn't good enough. If Priceline wants these terms to hold up under scrutiny, visibility and clarity must be strong enough to show real user awareness. Now, let's talk about the unilateral agreement clause, the part of the contract that says Priceline can change the terms whenever it wants, without notifying users. It's a powerful clause, but it comes with some legal risk. In Douglas v. Talk America, the court ruled that a company cannot bind users to updated terms if the users were never specifically told the terms changed. Silence might feel efficient, but it's not enforceable. A simple notification system would take this clause from questionable to defensible. Priceline's arbitration requirement is common in the travel industry. It eliminates court proceedings, jury trials, and class actions. This is not unusual, and courts, including in AT&T versus Conception, have upheld arbitration agreements. But enforceability still depends on notice and clarity. If arbitration is going to be the required path for disputes, then users must be made unmistakably aware. Otherwise, Priceline risks losing the very protection it put in place to avoid litigation. A more recent decision, Belsky versus Coinbase, confirmed that arbitration clauses can still be enforced, even today. But the dissent raised a warning. When users have no meaningful choice, the fairness of the agreement comes into question. So for Priceline, this means that while arbitration is legal and legally valid, increasing transparency will make the terms more defensible and more aligned with modern expectations of informed consent. So the question becomes, can users sue Priceline? Technically, yes. Practically, the terms limit almost every path they have. Class actions are out, jury trials are out, court litigation is mostly out. Individual arbitration or small claims are the only options. The Supreme Court decision in Lamps Plus versus Varela supports Priceline's right to limit class arbitration. But again, only when users knowingly agreed. That's where clarity becomes the deciding factor. As it stands, Priceline's terms are functional, but they carry many vulnerabilities. Users never actively consent. The terms rely too heavily on passive browsing as agreement. The amendment clause lacks transparency. The arbitration requirement isn't highlighted, and important provisions are wrapped in dense legal language that the average user won't understand. None of these issues destroy the contract, but they do weaken it. The good news is that these vulnerabilities are indeed fixable. Adding a click-to-agreement step would instantly strengthen enforceability. Simplifying the language into clear, plain English summaries would improve transparency. Highlighting arbitration would prevent disputes later, and notifying users when terms change would eliminate the risk tied to silent updates. These improvements don't reduce Priceline's power. They enhance it by making the contract stronger and harder to challenge. Section D is Priceline's indemnification clause. In plain terms, if a user breaks the agreement, violates the law, or causes harm through their actions on the site, Priceline can require them to cover the resulting claims and legal fees. Clauses like this are pretty standard, and they hold up when the claim is valid. Courts confirmed that in Hot Rods v. Northrop Grumman, stronger user content would make this protection more secure. Sections E and F protect Priceline's intellectual property, everything from the site's text and graphics to its trademarks. They also lay out the DMC process for reporting copyright infringement. This language is pretty standard across digital platforms, and courts generally uphold companies that follow DMCA rules, like in Viacom v. YouTube. Even though these sections rarely cause disputes on their own, they still depend on users clearly agreeing to the terms. Terms of use aren't static. They evolve constantly, and organizations like the Electronic Frontier Foundation track those changes closely. Today's digital landscape demands clarity and fairness, not because the law requires it yet, but because users do. Companies that adjust now stay ahead of regulators and build stronger relationships with their customers. At the end of this evaluation, here's what I see. Priceline's terms are workable, but outdated in certain areas. They're valid, but vulnerable. By modernizing consent, visibility, and update procedures, Priceline can create a user agreement that is not only enforceable, but also aligned with current legal expectations and consumer standards. Thank you for allowing me to review your terms and conditions. If Priceline moves forward with updating its terms, these recommendations will help create a stronger, clearer, and more enforceable agreement. I am available to support revision, implementation, or any follow-up analysis the company may need. Thank you for listening.